Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
All caps means you're either panicking or trying to represent yourself in court. Both are mistakes. Your feelings are adorable, but they're not admissible, persuasive, or even interesting without evidence. Yes, Heather hates immunity doctrines. It's a personality trait at this point. You don't need to remind her, she wakes up angry about it. Bring receipts. No, I heard it from so and so. This is quid pro quo, not next door. Screenshots are statutes only. Don't fight each other. Fight the law. It deserves it more. If you're offended, excellent. That means you're awake, paying attention, and probably new here. No diagnosing the host. She's petty, not pathological. And don't diagnose anyone else. Stay in your lane, please and thank you. Do not summon the mods. They're tired, hangry, and may bite when provoked. Disagree loudly if you must. The algorithm eats drama for breakfast. Just keep it cute while you argue wrongfully. If you're taking screenshots of my chat, touch grass, tell your handlers. I said hi, and find a hobby that isn't me.
Hey everybody, how's it going? So I do know before we get started that there are new docs and new information in the What the Hales case, and Federal 2 has a something or another. However, I did promise you guys this today. I have some more information on this topic in particular, and I need to take a rest because I'm feeling very petty today, which is why I played the petty rules intro. We need to take a break on this channel from the Battle of the Narcissists round 300. There's been a couple comments on Facebook lately of like proving my point about both sides sucking ass. And we need to take an extended break from all things. What the fuck is wrong with these people? Because somebody asked a simple question on Facebook. This set me off yesterday. So, like, if this tells you what sets me off, somebody asked a question in one of the Facebook groups, and for some ungodly reason, I was paying fucking attention like a dumb fuck. My fault. And they said, "Who is everybody's nicknames? Because I'm having trouble keeping up." And someone accused them of being a troll because they asked a question about nicknames. I've followed this case since Judge Grudge, and I still can't keep up with people's fucking nicknames. Paranoia on both sides of that case is fucking unreal. So we are taking a break from the battle of the narcissists and their cult followings. With that being said, we are going to watch the Tyler Robinson hearing from yesterday. It is only about 25 minutes, if that. I do have it sped up because the judge talks slow, in my opinion. However, we want to slow this down because I do have the transcript that they are talking about in the released hearing. And we're going to go through that. And I want to slow it down and be very precise in this, because there's some important things that I figured out from skimming and just doing. When I get a document that's 97 pages long, I don't read the whole thing. I do like keyword searches. I will search for like certain key phrases that I am interested in and I want to see if they're there. And I found a couple things that I thought was very interesting and relates to yesterday's stream. If you didn't see yesterday's stream, we talked about the defense's motion to get rid and disqualify the entire Utah County Prosecutor's Office. Well, that's important to what happened in that October 24th hearing. That was it was behind closed doors. But now the transcript is redacted, but it's out. And what matters here is not commentary, it's what's actually made it into the court record. So, reading through that sealed transcript and what that hearing was actually about was the shackling and the courtroom security, and we'll get into that, and some procedural stuff, which is very important. But something very, very, very important that I don't think I would have thought happened from reading that transcript under seal. The defense had already raised the district attorney conflict back in October on the record in that hearing. And I don't mean hinted. I don't mean implied. Defense counsel told the judge explicitly during that October 24th hearing under seal that a family member of a Utah County prosecutor was present at the Charlie Kirk shooting, and that individual was approximately 85 feet, that they fled the scene, and that the entire Utah County Attorney's Office was aware of the situation. That discussion occurs early in the transcript. We're not going to go through the whole 97 pages. We're going to hit highlights of it because we don't have that much time. Defense counsel is laying out the roadmap of upcoming motions, including a, quote, motion to disqualify the Utah County prosecutors from this case. Utah versus Tyler Robinson, October 24th. And this is critical because the judge allows that discussion to take place under seal. Defense counsel even states on the record that they are taking advantage of this sealed setting to address issues that should not be litigated publicly. And however you feel about the Tyler Robinson case, whether you think he is the guiltiest party in the world, or you think there's some larger conspiracy and he is the fall guy, the defense is being very intelligent in this situation. It tells us two things. This conflict of interest is not a new situation. It is not internet noise. They did it under a sealed hearing. They're not trying to get attention from the media. And secondly, the court was already aware that it raises sensitive due process concerns before the motion was even filed 2 months later. The motion was filed in December. The defense also connects this to broader concerns about information flow, noting overlaps between prosecutor's office and the sheriff, and a warning about the dangers of blurred lines and different roles when confidential information is involved. And that matters because conflicts aren't about intent. They're about appearance, access, and influence. This transcript is not about the motion to disqualify itself. It's just something that is important and lays the foundation for the motion that we read yesterday, which if I didn't have this transcript today, my opinion of that motion changes a little bit. But this is the probably the best lawyering that I've seen. And this is a layperson's opinion. I am not a lawyer. I don't claim to be a lawyer. But from a common man's perspective, this is probably the best lawyering from a defense team that I have seen since I've started this channel and maybe since Rittenhouse. This is this is how you lay the foundation for your future defenses and appeals. Like, oh, anyway, we're going to watch the the hearing first. But how is everybody doing today? Flash fan, how are you? Thank you so much for your help with this. Flash fan is my ride or die, man. Flash fan is the boss. Flash fan is amazing at everything he does. And if he tells you he's not, he's lying. Just telling you. He's amazing at everything he does. Kirby, I got your email. Thank you so much. Gail, how are you? Jeffrey, I see you. God is good. Oh. And you sent me a picture and all I saw was like snow and I'm like, I'm just not even going to open this. No offense, but I'm having a good day and that was just going to bring it down. Yep, and everyone please hit that thumbs up. And John H, I see you somewhere. I saw you somewhere. Hey, how are you? And yes, this is at my normal time. I did tell you yesterday that I was going to be streaming early. However, my appointment today was canceled due to unfortunate circumstances of a few people being very ill and I'm not wanting to share germs with me, and I greatly appreciate that. I've already got enough crap on my own going on. I don't need influenza A either. Today is really dragging. I need something to focus on. Well, I've got that for you. And Jeffrey, thank you for the $5 super chat. Last super chat of the year goes to Squid. I feel honored. May this help start next year off in the green and keep the wallet from getting too lean. Oh my God, I got my credit card bill statement because I've been in denial. I usually check my accounts like every other day, so I stay on top of shit. I haven't checked in like 2 weeks because I've been in denial. If you see me busting my ass and being a little grifty the first 2 to 3 weeks of the year, either contribute or mind your business because I a little overspent. I overspent to the tune of an amount of my credit card bill that I have not seen my credit card bill this high in years. This is about 3 months worth of credit card bills in one. It's not fucking pretty. So it's gonna be no spend January. And if you see me doing some grifting, either participate or mind your business because mama got bills to pay. And yes, Mr. Squid and I work together on things, but we keep certain spending separate, and the spending we kept separate is what I overindulged on. Just like I overindulged on sugar, I overindulged on spending too. So, it's just Flashfan, you're a very handy person to have around when it comes to information. Flashfan is a very handy person for like self-confidence, um, information, research, cases that he knows I'm interested in that I haven't heard about. He'll text me, "Hey, have you heard about this? Have you heard about this?" How he does what he does, I have no idea, but he is like my little brother. He is like amazing. Yes. Hey, John, how are you? Summoning the mods because I'm a masochist. How are you? I haven't seen you in so long. How are you doing? Uh, all right. I'm sick today. Just gonna listen. Oh no, Roy, I feel better. Uh-oh, putty alert. It's more of like a just a sick of drama, useless drama. Like people being dramatic for absolutely no fucking reason and going out of their way. I and yes, people will be like, "Well, you're mean to people." I'm mean to people who are mean to me or mean to others. But I just don't go out of my way to be an asshole because that's just not me. But people who go out of their way to be an asshole to other people for asking a simple question fucking set me off the last few days. And I'm like, I'm about to burn everything to the fucking ground. And if you know what I mean, you know what I mean. Like, I was talked off of a ledge yesterday of like doing a video on an information dump of the last 18 months of fun. I was talked off a ledge of burning everything to the fucking ground. Oh, Mr. Squid is gonna hear you. Yeah, he knows. Uh, just admit it, Squid. You overspent. Ouch. Oh, yes, I did. Hey, Jen. All right. Walmart actually carded me for Cortis and HPP and cold and flu tablets. So I'm so with that, they have to enter something into the computer. They have to enter a date of birth into the computer. So it's like because they card me too, and she was like, "I have to enter something. It's not you." And I was like, "Oh, well, thanks for that." So, well, Sudafed they get you because Sudafed, the actual like Sudafed, um, they like Walgreens when you go and buy it there, they track how much you buy because you can only buy a certain amount in a certain time frame because that can be used to make a certain illegal substance if you know how to do some science. Not saying I know how, but I'm just saying that's why they track it. uh, all right. Hey, Wes and Bama. I'm trying to get my mother moved out of her old house, and I want to run my head through the thickest piece of drywall in this house. Yeah. Yeah. So we're gonna get to this hearing because before I get hate comments of you didn't actually get to the fucking hearing. Yeah, between the cold, the back and forth temperatures making this patch in my skull. It's not in my skull. It took the place of my skull. They took a piece of my skull and they didn't give it back. And they put a Dura patch on my brain. And you can feel it. It feels funky. But doing some research, I never thought that it would expand and contract with the weather. Well, lo and behold, when the weather changes from like 30s in the morning to like 60s in the afternoon or 70s one day to 30s the next, I can feel my brain, the pressure on my brain. It's fucking weird, but it hurts. And then I got sick on top of that. So, it's if it's not one thing, it's freaking another. But this whole month has been shady. But I am working on I did get to actually like walk on the treadmill this morning, and the whole time I was working in my calendar program and having AI help me organize my calendar for next year and like how I'm gonna do stuff. So maybe we're gonna get a little bit more organized with some shit. We'll see. Best of intentions. I researched your patch. Oh my God, it's good. It changes with the barometric pressure. Ye- Squid, if you sneeze really hard, will your brains fall out? No, because that patch is there to actually keep my brain in my skull, because that was the problem. My skull was not big enough to fit my brain. So my brain was squeezing out of my skull. All right, let's get to this. I have it on 1.1 speed because the judge just talks really slow, in my opinion. So we'll get to it. There we go.
Court is now in session. Counsel, let's call the case. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Could the parties please enter their appearances?
Governor Christopher Ballard, Chad Grunander, Lauren Hunt, and David Sturgill on behalf of the state.
Good morning.
Catherine Nestor, Michael Burt, Richard Novak, and Stacy Visser on behalf of Mr. Robinson.
Good morning, counsel.
Good morning, Your Honor. Jeff Hunt and David Ryman on behalf of the Deseret News, KSL, and other media interveners.
Good morning, Your Honor. Michael Judd on behalf of the Salt Lake Tribune and other media interveners.
Thank you.
And we are watching this on KSL News Utah because they just show the actual hearing, whereas Court TV shows their pundits and their talking heads for way more time than I care to watch those people. No offense to them. I'm sure they are nice people, but we got shit to do. This judge is kind of inconsistent. He wants stuff to be secret, but then he doesn't on one hand. I see his point about not wanting a media circus. I'm not sure how to feel, because I see, from what I've understood, what I've seen, it kind of is like he's torn as well, and I think he's having a mental battle, because I fight this mental battle all the time of like watching people and being like, you want to be transparent, but you also don't want a media circus. You want to be transparent, but there are things like yesterday, Flash Fan, you had mentioned that the coroner's report, it's not released in any normal state case. So why would it be released this time, even though people are pushing for it to be released because it's Charlie Kirk and there are conspiracies around the bullet and all of that stuff. So it was like, I see. That's why you'll never be a politician. Your brain is too big for your skull. Well, I would never be a politician because I actually give a shit. And that's the problem, is politicians are only out for themselves and they lie. And I can't lie because I can't remember my lies. It's kind of the benefit of having cognitive issues. I can't lie because I can't remember. This is me. You'll see my ups and you'll see my downs because this is just me, because I can't fake being somebody because of the fact that I can't remember who I was pretending to be. I can't remember. Like I was telling someone yesterday, I had to be talked off a ledge yesterday because I was so like, fuck everything. That's why I call it the battle of the narcissist, because I'm like, everybody's got an ego, everybody's got a narcissist, everybody's fucking paranoid. Like, y'all are crazy. So I'm like, I have a bad feeling these people are out of their safe places. Yeah, like brain size matters. Well, there's a difference between having a brain and using your brain. There's and hey, Malin, how are you?
Good morning to you. Mr. Robinson, are you with us?
Yes, Your Honor.
And Mr. Robinson, good morning to you as well. All right. The court appreciates the patients, the parties, while it considered issues raised by the media interveners. An appropriate classification of the transcript and audio recording from the October 24th hearing. The court has taken the necessary time to conduct a careful, independent review of the written submissions, oral arguments, and applicable legal authorities, and to thoughtfully evaluate the matters presented. In doing so, the court has remained mindful of its duty to balance competing constitutional interests. Openness and transparency are foundational to our judicial system and essential to maintaining public confidence. At the same time, the public's right to access is qualified, not absolute, and may be limited when a legally sufficient justification exists. The court recognizes the substantial public interest in these proceedings and has approached its review with that interest firmly in mind. The court has independently reviewed the October 24th transcript and audio recording in its entirety. In determining whether any restrictions on public access is warranted, the court considered whether such limitations are necessary to protect specific constitutional interests and whether less restrictive alternatives could adequately address those concerns. The carefully limited redactions ordered are narrowly tailored and designed to protect those interests while preserving the public's ability to understand the substance, context, and significance of the proceedings. By way of context, the transcript of the October 24th hearing consists of 83 pages, 80 of which contain verbatim record of the proceedings. Each page includes 25 lines of text, and the transcript reflects just over 2 hours of the courtroom proceedings. The duration of the that hearing was 2 hours and 19 minutes. The closed hearing held on December 11th included detailed arguments from defense, prosecution, and counsel for the news media regarding what portions of the record should remain private and what should be made public. That hearing likewise lasted nearly 2 hours, during which time counsel addressed these issues carefully, line by line and word by word. The court acknowledges and appreciates the diligence, professionalism, and preparation demonstrated by all parties during both hearings. After full consideration of these arguments, the court determined that 246 words, approximately 1 page of the 80-page transcript, should be redacted. No other portions of the transcript were found to warrant restriction. The court further notes that the matters addressed during the October 24th hearing, including issues related to civilian clothing and shackling, are best understood when considered in their full context. The limited scope of the redactions reflect the court's effort to preserve that context to the greatest extent possible. The redacted transcript will be promptly filed on the docket by the end of today. The corresponding audio recording will require additional time to ensure that it precisely reflects the approved redactions and that no protected material is inadvertently disclosed. The court anticipates the audio recording will be available within approximately 2 weeks. This court notes the importance of the audio in addition to the transcript because hearing what was said and how it was said is equally as important as just the transcript itself. The court's sole objective in this process has been to ensure a fair, orderly, and lawful proceeding that reflects the constitutional rights of the parties while honoring the public's qualified right of access. The court notes that the standing decorum order has also been updated and directs all parties to review the order in advance of future hearings. Accordingly, the court now...
Oh, he updated the decorum order. I can't wait to read that. But he's got a point. Like, you need to maintain someone's rights while still giving the people the openness and transparency that the public deserves. I see his point, but the part where I disagree on some of the things that the judge says is, remember, Charlie Kirk was shot in public. So why should anything Tyler Robinson does be behind closed doors when Charlie died in front of thousands of people, millions of people, because that video was shared over and over and over and over again on multiple social media platforms before it was taken down. Or before people stopped sharing it because they realized how absolutely gruesome it was. I generally think I can handle a lot, and even I was like, I'll pass. I saw it, I shared it with a couple people, and then I was like, yeah, then no more. But I don't know. It's not an easy thing. And remember, like John said, that there's a lot of gray area in the law. And this is where the judge has discretion, and not everybody is going to like his discretion, including me. But that's okay. Yeah, when it's secret, you get into potential bias issues and corruption issues potentially. And when it's too open, you get into due process and mob rule and people and having a tainted jury because everybody's seen everything. So there's a happy medium there. I'm just not sure what that is. But that's what the you know, exactly, Melon. And that was kind of my point. That was actually my point. You admit that you don't know everything because you're not from here, and that's perfectly acceptable and okay. But you're here to be entertained, to learn, to watch. There are people in this country who have never seen the inside of a courtroom, yet think they know everything that should happen in all these cases and act like they went to law school, who don't even know that speeding is illegal or not wearing your seatbelt is illegal. Or they'll use the excuse with the cops, well, I didn't know that was illegal. Well, not knowing the law doesn't make it does not make you immune from it. So it's just one of those situations of there are people in this country, especially a lot of people who I've seen on YouTube, who have just crossed a lot of what I believe is ethical and moral boundaries and wingnut conspiracies. Left wing nut, right wing nut, it doesn't matter. Just and I fancy myself of like a conspiracy theorist from time to time. However, some of these conspiracy theories that I've seen flying around don't make a damn bit of sense if you know anything about ballistics, any sort of pew-pew, or the legal system. They don't hold water. Or anatomy and physiology. There's another one. You know? So there's that. I think it's not, yeah. Thank you. That was what I was trying to go for. Ignorance of the law is not a valid defense. I was watching a video right before this from Cartier family. I think that's how you pronounce their name. Of watching somebody get pulled over, and it was just he's like, this woman was like, I didn't know that, not wearing a seatbelt was illegal. Like, yeah, okay.
Now issues the following order regarding the classification of the transcript and audio recording of the October 24th hearing. And turning to the order itself. The state of Utah and defendant Tyler James Robinson filed a motion to classify the transcript and audio of the sealed October 24th, 2025 hearing as private. Because the press requested notice of all such motions, the court held a closure hearing on December 11th, 2025 to address the classification of the transcript and audio recording of the October 24th, 2025 hearing.
Okay, devil's advocate, what would fix that? We're gonna back that up and listen to that part again, because it would fix the media wanting copies of all or awareness of all motions that are filed. Don't make documents in Utah have to be paid for. Make your documents like Florida. The media doesn't need to be alerted. The media can just go look for themselves. And if they don't look, then they don't get alerted. They have to do the research themselves. The court doesn't have to do shit. But, I mean, that would make your documents free, and it would save the court a shit ton of time.
Prior to that closure hearing, the parties filed a joint status report identifying some 20 provisions of the transcript for redaction and stating that the balance of the transcript may be classified as public. Having reviewed the relevant pleadings from the parties and representatives of the press and heard oral arguments during the December 11th closure hearing, the court now rules and orders as follows. The public has a presumptive right to access court records. See Utah See Utah Rules, Judicial Administration 202.02 sub 1.
So Utah, make your shit like Florida. So Georgia is a weird kind of a state. Georgia, you can access the documents online and view them, but in order to download them, you need to pay for them, and they're fucking expensive as hell. It's like $25 for a 5-page document. Make it make sense. But you can view them online, or at least in the 3 counties that I've tried in Georgia, I've been able to access them online, but I have not been able to download them. Athens, Clark County, Carrollton County, and Fulton County. However, I can still access them and see them. Florida is free because it's Florida. But like, at least make it like Georgia, where I can see them. Alabama, Mississippi, Utah, you have to pay for them. You have to pay just to access them. And it's like Utah, you have to pay monthly. And it was like, I think it was like $40 a month to access the documents. And it was like, if I paid $40 a month and there was no documents filed that month, I just wasted $40. That's the kind of crap that like Utah pulls. It's just, yeah. Well, and Calvin, if we do remember our history correctly, a very important figure in our U.S. history, Martin Luther King Jr., who was also tragically unalived in a public fashion, was also shot with the same kind of weapon, and there was also no exit wound. So this is not an unusual thing. It's just a weird, and Nicholas, when Chargers fan. Ooh, Chargers fan. Thanks for the $1.99 super chat. Stop acting like Charlie Kirk is a hero. I'm not acting so much like he's a hero, but he did have a really good way of acting because he never, and I liked the way he handled when he disagreed with someone. He gave someone room to talk when he didn't agree with them. And that's my whole situation. And that's why I have people in the chat who don't agree with me on a lot of topics be in one of my one of my what the hell streams. There's people who hate watch me in that one all the time. There's people who yell at me all the time in those ones. I don't think we should live in an echo chamber where we only listen to people who agree with us. Because if we only listen to people who agree with us, we're only going to hear what we think is right. And we're not always right. I'm not always right. I'm wrong a lot of the time. I didn't agree with everything he said. I don't agree with all of his positions. However, I do agree with the way he went about things. And also realizing that like change comes from the young people, because us, oh my God, I can't believe I'm just referring to myself, us older people, and I know y'all, I'm not old, I'm 40, I'm middle-aged, but like we're already kind of set in our ways, and it's harder to get us to change our minds. It's possible. I change my mind all the time. I don't like always being, I always say like my mind is moldable. Like I'm open to other opinions because I admit I'm not always right. But I don't think we should live in an echo chamber because we only hear what we want to hear. And that's where I think on both sides these radical ideas come from, is we always hear what we want to hear. And then we get this like, it happens in the Hales case. And I have, yes, right here, not a hero in the traditional sense, but he was influential and important. And he was a victim. Yes, and Flash fan, I agree with you on this. He was a victim and not regardless if he was a hero or not a hero, no one deserves to get unalived. We are not judge, jury, or executioner. And that is where Flash fan, I love you like a little brother. And I noticed that you have the picture of the dog in your profile, and I thought you hated that dog. I just noticed that. it's just one of them situations of like when we only talk to people who we want to talk to and who we want to hear. It's how these far ends of both sides of the spectrum, it's how they get so extreme is because they hear what they want to hear and they just keep being more pushed toward each side because you're in an echo chamber. Whereas like the vast majority of us who realize that we're not always right. And it takes a lot to admit that you're not always right because ego is a powerful thing. Like y'all know I have my brain book that sits right there. Psychology is kind of my thing and brain anatomy is kind of my favorite thing. But like I I am not. I am not. I never said I agreed with everything he said. I agree with everything he did. However, I agree with discussing ideas with people that you don't agree with because that is the only way that we're going to start meeting some common ground somewhere. If we all live in echo chambers, we only hear what we want to hear, we don't hear ideas from other people, then we only our beliefs get reinforced even though our beliefs may not always be right. If we talk to people who only agree with us, they reinforce the positive beliefs, but they also reinforce the negative behaviors too. And that's the problem. Yes. Yeah, and then nothing like taking things out of context. And that's the thing with a lot of things is people take things out of context a lot. If you listen to that whole thing, it was comparing it to car deaths in the sense of people cut themselves when they're cooking. Are we going to? Yes, it's going to happen. Is it tragic? Abso-freaking-lutely. Should it happen? Hell no. But does it? I black out on his name all the time. Fort Brooks, Daryl Brooks killed a bunch of people and injured a bunch of people in my community, my hometown, with a car. Like evil is evil. It's not about the weapon or the medium of how it's done. Evil is evil. And evil is evil. And we need to admit that evil exists. We also need to admit that not everybody is, and this is difficult to say, but not everybody is, we can't smile and blow sunshine up people's butts and make them like us. If someone's going to be evil, they're going to be evil to you no matter how nice you are to them. Yes, treat everybody with respect. But like if someone wants to unalive you, they're going to unalive you whether you are an asshole to them or you are the nicest fucking person in the entire world. And that's what I don't think that we admit to ourselves enough. That like don't go out of your way to be a jerk to anybody. Hell no. Am I a little petty to people that have been rude to me in the past? Of course. But like I'm petty like if I know your email, I'll sign you up for like spam emails or like I'll sign you up for like Lululemon emails when you're like a 300-pound dude. Like funny, annoying, but not harmful. Kind of petty. However, it's one of those situations where it's like, uh-oh. Oh no. Okay. All right. Hey, King Paco. I hope you're having a wonderful day and you had a blast holiday. We finished our holidays yesterday. It was exhausting, but it's good. No, the only person who I've done that to is Beelzebubbles. Hey, Timothy. Yeah, and changing the definition of words. And understanding that we don't like mental health issues. Like I have depression, I have anxiety. Realizing that it's okay to have those things and not to stigmatize someone for having a mental health issue, but also not glorify people for having a mental health issue. Not treat them differently, but admit that people need help. But also don't try to blow up Well, provide evidence, because you've only said one thing, but it was taken out of context. And that's what I'm like, I don't want to argue with you, but I understand not liking evil people, because I don't think anybody likes evil people. But I think we changed the definition of evil to something that is, when we don't like somebody, we have different policy positions. I learned a long time ago, or someone taught me a long time ago, that um the two sides of the aisle, and I've noticed this with my more liberal leaning friends, the left or the right thinks the left, or at least we used to. I'm more like, just leave me a hell alone kind of person. If you've been on this channel for more than like a day, I'm just like, I hate the government. I'm the more anarchist I've become. But I'm more of the right used to think as the left as good people with bad ideas. The left just thought of the right as bad people. That was the difference. And it's the more and more I see it, the more obvious that becomes to me. Like, you just, people that you don't agree with, you'll call evil. And it's like, yeah. So, yeah, having a different opinion or position on a topic doesn't make one evil. Note to self, don't piss off Squid. That bad. Jeez. Like, I'm not that bad. All right, let's get back into this, because we do have the transcript of that hearing. And I also have to go to work tonight. So, and Mr. Squid is home, and I'm pretty sure he gets annoyed whenever I get on the fucking computer when he's home.
That right, however, is not absolute. To support and achieve certain interests and objectives, a court may close portions or entire court records. Court record. A court may consider any relevant factor, interest, or policy, both in favor of and opposed to closure, in determining whether to redact portions of or close all or part of a court record. In deciding whether to redact or close a court record, a court must balance the interests favoring opening and closing the record, and if it determines to close the record, determine there are no reasonable alternatives to closure. The parties have argued, and the court has considered, the following policy interests in determining the motion. 1, protecting safety interests. 2, protecting privacy interests and non-party participants. And 3, protecting the defendant's right to a fair trial. Approximately half the portions of the transcript the parties seek to redact address courtroom and courthouse security measures. Safety concerns are well recognized as justification for closure of court records. This undoubtedly includes references in the court record to specific safety measures undertaken as part of the court security plan and practices in highly publicized cases. This case generates extraordinary ongoing national and international attention, some of which is threatening in nature to the parties, their representatives, and non-party participants. The safety and well-being of all involved in this matter outweighs the interests of the public that are served by open court records. Nevertheless, and as the parties recognize, the court need not seal the entire transcript and audio of the October 24th, 2025 hearing to protect the safety interests of all those involved. Redacting selective portions of the transcript and the audio that reference security measures will serve safety interests while allowing for as much public access to the remainder of the record as possible. The court hereby orders the redaction of the portions of the transcript corresponding audio referencing security measures identified in the parties' joint status report and further pared down during the closure hearing. These include the following portions of the October 24th, 2025 hearing transcript. Page 4, line 19 through 22, following the word unshackling until the sentence begins with the word and. Page 4, line 25 until page 5, line 1, including the first sentence of the last paragraph. Page 5, line 9 through line 10, following the word proceeding and ending before the word but. Page 5, line 18 and 19, including the entirety of the bailiff's comment. Page 33, lines 17
And
through
I'm kind of
18, following.
I'm kind of going to skip this because all he's going is through what they're redacting, and that's just kind of a waste of time because we're going to look at the transcript and it's not important.
Word that until the end of the paragraph. Page 43, until the end.
I'm all about talking about it and listening to it, but I'm also not about wasting our damn time.
Of that paragraph. And finally, to justify the closure of a court record, a privacy interest must be more than a desire to avoid annoyance, criticism, or embarrassment, and must serve to protect information of a highly personal nature. The parties initially identified 6 portions of the transcript to be redacted based off privacy interests. During the closure hearing, the parties withdrew defendants' requested numbers 1, 2, and 11. The remaining 3 requests were significantly pared down. The court has already ordered the redaction of request 3 for security reasons, including page 34, lines 5 through 7, as ordered above. The court also finds that privacy interests support this redaction. The court has considered the interests favoring closure of the remaining 2 requests for redaction and concludes that the information is not of a highly personal or sensitive nature. Privacy interests do not outweigh the public's interest in this case. Therefore, the court denies redactions of the following portions of the transcript: page 35, lines 16 through 17, and page 80, lines 22 through 25. The right to a fair trial seeks to ensure that the one accused of a crime will have his guilt or innocence determined solely on the basis of the evidence introduced at trial. Thus, if disclosure of information poses significant risk of endangering a defendant's right to a fair trial, then closing or sealing a court record to protect that information is justified. Nevertheless, when such information has already been introduced to the public arena, there is a suggestion that no additional damage can be done, and the issue of sealing or closing the record becomes moot. Here, the Joint Status Report identified 4 portions of the transcript for redaction, based on the argument that redaction is necessary to preserve the defendant's right to a fair trial. The court is unconvinced that the disclosure of the selected portions jeopardizes that right. The information in question is contained in the charging instrument, whether directly or indirectly, as part of the factual allegations made against the defendant and already part of the public arena. If this information poses a risk of violating the defendant's right to a fair trial, defendant's first line of defense is found in the rules of evidence and criminal procedure. Closing or redacting these portions of the transcript in audio is outweighed by the interests and the objectives served by open court records and mooted by prior disclosures in the information. Therefore, the court denies the request to redact the following portions of the transcript in audio: page 55, lines 2 through 7, page 60, lines 24 and 25, page 61, lines 1 through 6 and 13 through 14, page 64, lines 11 through 17. These portions also refer to a potential non-party witness. The court has considered redaction to protect the non-party participant from risk of retaliatory physical or mental harm. However, the reference is made to that non-party participant during the October 24th, 2025 hearing offers the same but no additional information that can be found in the charging instrument and shared by law enforcement during a press conference. As a result, redacting those portions at this point is a moot issue. For the above reasons, the court orders the following: a transcript of the October 24th, 2025 hearing shall be redacted in accordance with this order and entered into the record, and the audio recording of the October 24th, 2025 hearing shall be unsealed for the purposes of the court clerk identifying the timestamps corresponding to the redacted portions of the transcript, which selected portions, once identified, shall be resealed. No copy of the unsealed audio shall be provided until the identified portions have been resealed. The court will sign this order today, and it will go into the record. Now, turning to the second issue. And the court now issues the following order regarding the media's request to intervene. 2 groups of media outlets seek to intervene in this matter. Only the state and the defendant, however, are actual parties to a criminal action. The press need not be a party to a criminal action to pursue the public's presumptive right to access public court records. The press has already been provided with a mechanism through Rule 4-202.04 to protect that right and has already utilized it in this matter. For this reason, the court denies both requests to intervene. The court now reiterates and clarifies its order requiring parties to serve all closure or reclassification motions on the media dated November 10th, 2025, as follows. Again, the parties are ordered to serve all closure motions on members of the press who have requested notice. The parties must file proof of service with the court. A closure motion is any motion to classify or reclassify presumptively public court record under Rule 4-202.02 as any other classification. The parties need not serve notice on members of the press court records that are presumptively not public. A court record means a record that is prepared, owned, received, or retained by this court. This includes hearings. Therefore, the parties are ordered to serve all motions to closure hearings on members of the press who have requested notice. The parties must likewise file proof of service with the court. Nonetheless, the parties are not.
Yeah, I have him sped up specifically because he's a talker. He reminds me of the judge in Georgia with the TikTok teen case that very monotone and very like, I'm here. We're going to go nice and slow and steady, and I'm going to be articulate, which is nice to a point. To a point. A little inflection would, yes, Judge Hightower. Thank you. I could see the hair. That it's like the Judge Good hair, not the Tuft of Justice, but and not Dr. Good hair, but like Judge Good hair, like Uncle Jesse kind of hair.
Not required to serve notice on members of the press of motions to limit electronic media coverage. If members of the media intend to object to a closure motion and request a closure hearing, such objections and requests must be filed within 7 days of receiving notice. To promote judicial economy and to eliminate unnecessary hearings, the court may decline to hold a closure hearing if no hearing is requested. The foregoing should be treated by the parties as a standing order for the duration of this case. And that concludes the second order of this case. The court wishes all parties a peaceful holiday season.
Yeah.
And hopes that each of you
Don't care. That's pretty much the gist of it. I like Dr. Good hair. Yeah, me too. Dr. Good hair is a good one. I need to email him and reach out. I want to see if he'll want to be on my other channel because I have some things to ask him from a hospital administrator's perspective. Not Squid to, CMO or Dr. Good hair, but like OTA Heather to an evidence through motion to CMO Joe, Dr. Joe. I have questions, especially when it comes to this Aurora Advocate Aurora lawsuit, because yeah. Well, he did make a comment on my video about when I covered his lawsuit against his former employer about his retirement money. However, they were going through mediation like the next week, and I never followed up. So, isn't there a Dr. Good hair in a 007 film? I don't know. I don't know. But there is I have questions. I have questions about a lot of things. I have questions about a lot of things. I don't ever claim to be an expert on anything. I just ask questions and talk to people who are smarter than me. Because, they would know. All right, let's get rid of this. And let's share this document. Because it's so you can see, this is what I do. I You can see I was looking for conflict. So this is the transcript. And you can see there are parts that are redacted. It is 97 pages. We are not going to go through the whole thing because, this judge does like to talk. However, there are just some things that we need to discuss. And what I found most interesting about this had absolutely nothing to do with the whole point of this hearing was the shackles and all of that. What I thought was the most interesting portions were portions that discussed the stuff we talked about yesterday. And sorry, I was reading Flashbane's comment. I'll send the audio when it releases. I was thinking Uncle Jesse, Full House, Uncle Jesse. So, not Dukes of Hazzard Jesse. But the discussion of the conflict of interest. Because I know yesterday I was kind of I was totally in agreement with the defense. And this is where I play devil's advocate because I'm not a lawyer, never claimed to be one. I will repeat, never went to law school, don't want to go to law school, not even a paralegal. However, I'm just a layperson who would like to think I have some sort of common sense every now and then. Yesterday, it's all about how things look and the appearance of a fair trial, whether someone is biased or not. Appearance is everything. And it's important that whether you think that Tyler Robinson is the guiltiest party in the world or you are jumping down the conspiracy theory rabbit hole and thinking that he is the fall guy and he's a patsy and he had nothing to do with it and it's this person and this person and this person, whether you think Charlie Kirk is the second coming of Jesus Christ or you think Charlie Kirk is the Antichrist, that doesn't matter really in this. What matters to me anyway in covering this is if Tyler Robinson doesn't get a fair trial, today it's Tyler Robinson, tomorrow it's you or me. This is why I will never take the opinion of mob rule. And generally when it comes to covering the conspiracy theories, we talk about them in a way that we use common sense and try to dismantle them. I did not personally know Charlie. Like I said before, I did not agree with him on everything. However, just being a decent human being, will never, ever, ever celebrate anyone's demise. Ever. Even my worst enemy will never celebrate someone being unalived, especially in front of their wife and children. I just can't see myself being that kind of person. This is not a safe space, but this is a common sense and logic place. We bring receipts and not go with, oh, I heard it from this person or I heard it from this person and all of that. This is why we talk about the documents, and we also play devil's advocate and listen to both sides. And although the facts might lean us towards one side, we don't just hear one side and go, you're wrong, you're wrong, you're wrong, you're wrong, you're wrong. No, you talk to people you don't agree with. You listen to both sides. And I would like to think that in a situation I like to hear what the judge hears. I would be the judge and trying to be the non-biased party. Yeah. So what I thought was the most interesting in this is that there's a couple things that are funny. They introduce themselves, blah, 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 So when I was reading through this, they wanted him unshackled so that he could take notes. I'm trying to think about if you have handcuffs on, Even Sarah Boone was able to take notes while she was in handcuffs. So there's just part of this just doesn't add up to me. And maybe I'm completely out of my element on this one. If y'all can come up with a reason why, if he's in different shackles, I don't know. I've never actually seen him in the shackles. However, just regular handcuffs. Remember Sarah Boone and her pretty pink handcuffs? She was able to take notes during every hearing because Lord knows that woman loved to write. She was able to take notes with handcuffs on. So, color me confused on this one. I don't, and I don't think Sarah Boone got any less of a fair trial because she was in handcuffs during her pretrial motions and she was in jailhouse attire. I'm not seeing the logic here. Belly chains allow limited movement of hands for note taking, but shock belts are far less restrictive. What about just handcuffs? Does he have to be in like the full belly chains? Can he just be in handcuffs? I mean, that would, if people are really that scared of him, handcuffs still allows him to write. I mean, that could be a happy medium. I don't know. I understand the wanting a fair trial. Totally get it, because if it's him today, it's us tomorrow. But I just don't understand why he should be different than any other defendant, even in high profile and or streamed cases. Daryl Brooks was bolted to the floor under counsel's table with the tablecloth over the desk. Daryl Brooks also built a fort around his face so people couldn't see him. Like I said, I don't claim to know the answers to these things. I just brainstorm and ask you guys the questions that are running through my head in hopes to get some other ideas. Yeah, handcuffs you can still write. Could it be a local thing where he's being held, tried? They might have rules about shackles that didn't exist elsewhere. Maybe. I mean, and I'm sure county to county throughout the country, they've got different rules somewhere, but they claim to want, his defense attorneys claim to want the shackles off and him in civilian clothing in the interest of fairness. Why does he get treated differently than any other defendant across the country? Sarah Boone, always in, and I use Sarah Boone because that was high profile and that was she had a problem with every hearing being recorded. Cassep in Wisconsin, every hearing that I've seen, he's been in jailhouse garb. Carly Gregg, she was in the yellow jailhouse jumpsuit in Mississippi. The bad mom in Alabama that I have to figure out how I'm going to update that because the state's not being kind with documents on that one. But yeah, this is stupid. It's just, yeah. Handcuffed defendant while in open court at a trial, that would be a bad decision for any judge prejudicing a jury in appeal. Yes, but this is not about the trial. This is about pretrial motion or pretrial hearings. They want him in civilian attire and uncuffed or unshackled for every hearing, not just the trial. Every hearing. That's why every hearing that he's been at, you've seen him in a suit. Whereas other defendants before the trial, yes, in the trial, generally in civilian clothes and not shackled or not visible shackles. But They want him like that for every hearing. That's what I don't understand. What makes him special? See, he's not even in handcuffs. How harmful could he be? I would say, if anything, the court is going to be streamed or televised. She should be in civvies, and shackles should be hidden from view. Y'all, I will be right back. Ah. Mr. Squid we got a steamer, our steamer in the mail today, and he's steaming the floor. And he showed me how dirty the floor was, even though I generally mop it with our little mop. He's like, you can throw that thing away. So he came here to show me. Baby Squid to Telebreak. No, it was Mr. Squid's vacation projects. Yeah, this is in-person actions. I just don't understand what makes him different than any other defendant in the entire country. That's what I'm not understanding. But hey, if his lawyers were able to do it for him, good for them. Like, I just don't understand it. And I think that's one of those things that I'll never quite understand, what makes him more special than any other person. But this is where it got interesting to me. We're not gonna talk so much about the shackles because it's not really that important to me anyway. If y'all find it important, we can definitely read this word for word. But what I wanted to talk about was what I found here. So they say there are two other reasons why shackling, we believe, is the current shackling protocol and practice with respect to Mr. Robinson is unconstitutional, but those don't relate directly to the fairness proceedings in the traditional sense. Okay. I'm just going to leave that comment for, Here's where it got interesting to me. There's another motion, which we've also discussed with counsel for the state, and they're well aware that we're going to do this. Remember, this was 10/24. And this is a motion to actually disqualify the Utah county attorneys from representing the state in the prosecution of this case. If the Utah county attorneys want to represent the sheriff as an entity for security purposes, that's a different issue. We are focused on whether there is a conflict of interest, and we are in a sealed hearing. Correct, Your Honor? The court says yes. Okay, so I'm not trying to pre-argue the issue, but the Utah county attorneys have advised us that a family member of one of the attorneys was present at the incident in which Mr. Kirk was shot and killed. That this child, I don't know if they're an adult, but I'm not referring to them as a minor. That's an important distinction because, a child is still your child, even though But now we have what was redacted in yesterday's motion. You can kind of put two and two, you can kind of put two and two together. That this child, I don't know if they're an adult, but I'm not referring to them as a minor. This child was present, observed it, that was within 85 feet of Kirk when he was killed and had to flee. The Utah County Attorney's Office was all advised of this, that law enforcement, here's the kicker that we didn't hear yesterday. This is what and y'all can tell me what you think, and please, if you're on replay crew, please enlighten me on how you feel about this, because this was one of the situations and the little tidbits of information that was not mentioned in the motion yesterday. That law enforcement were actually deployed to that area with her safety and status in mind. That right there is like, okay, Utah County Attorney's Office, you can't, like, I don't know, like, they actually deployed law enforcement to UVU specifically for this girl. She's a family member of the of one of the supervisors in the county attorney's office. I read that full motion. There was a full motion from the attorneys, from the defense team, that was filed in December. This is a transcript from a sealed hearing in October 24th, or on October 24th. This right here. And I don't know if it was their child specifically, or a niece or a nephew, but it is a younger generation related to them. That was not in yesterday's motion. And when I say yesterday's motion, I mean the motion we read yesterday that was filed in December. I believe it was filed December 19th. No. Hold on. December 17th. So the motion to disqualify was actually filed December 17th, almost 2 months after this conversation. Yeah, when you hear that, when you hear that part, I was a little wishy-washy on it, saying that that particular prosecutor should have recused himself and instantaneously, like, said, I can't do this. My, my child or my family member was there. I'm going to, and the fact that he had shared text messages from them. However, the fact that law enforcement was deployed with her safety and status in mind at the direction of the county attorney's office, I have a big problem with that. Not should be fired, but should be disqualified from prosecuting this case. I agree. I'm not having the problem. Find her after the shooting. After the shooting. I don't have the problem with them doing it. And like, it's the context of prosecuting this case after the fact. That's the problem. There's where the appearance of the perception of the inability to maintain non-biased, and if you are made aware of evidence, here's the hypothetical. Because a family member was there, and that prosecutor is so focused on the fact that it's Tyler Robinson, if they are given any evidence that goes against their narrative, will they actually present it? And will they look, when they get evidence that says it might not be him, will they look for another person? Or will they be so focused on having their guy that they lose the bigger picture? That's the problem. And it becomes if it's not fair for Tyler Robinson, and yes, we could there are people who do not like Tyler Robinson. I can't say I'm a big fan. Whether he actually did this or not, I can't say I'm a big fan of his in general. Just based on what his family said some of their conversations were. Can't say we'd ever be friends. However, it's the appearance of fairness. And if this was your child as a defendant, or you, yeah, it's a definite conflict of interest. Yeah. I have no problems with the fact that they did it. I have a problem with the fact that they didn't disclose it or recuse themselves from the situation from the start. And they said, oh, there's no conflict of interest there. That's what I have a problem with. I'm not trying to pre-argue this. I'm not saying anything that we haven't already discussed a couple times with counsel for the state. We're going to file a motion to disqualify it, and all of these motions we've already talked about getting them filed before Thanksgiving, which they didn't. Yeah. That doesn't mean we want the court or anybody else to work over the holidays, but there's a lot of work there. And so we need a few weeks to get that all done. The court acknowledges it. And they address the state. I just want to make sure that from your perspective, the same understanding that we're addressing today, I just don't want to go down the path that one side says, wait a second, I thought we weren't going to go there. Like, okay. So that was yeah. And the interesting thing, they disclosed it. The full motion, the state has still not filed a rebuttal yet. That motion was filed December 17th that we read yesterday. I encourage you to go back and look at that full motion because it is 14 pages. So there is a lot in it. If the attorney called that type of power to find their child, what would they do in this case to see it through fairly? And the fact that the attorney in question is a supervisor. That's also a problem. There's a lot of so it's, and the fact that everybody is kind of like, the attorney himself should have recused himself. Who knows what he discussed with other people? He did say that he shared it around the office. It's the appearance of impropriety, or the appearance of the, it's the whole, it's not how something is, it's how something looks. It looks bad. Well, if it looks bad to us, what does it look like according to an appellate court? So hypothetical down the road, and this is hypothetical, just setting the scene. He is convicted. It is found that he did it, hypothetically. Well, now it goes to an appeals court, and his conviction is thrown out, and we have to start this all over again because these people didn't recuse themselves from this case and let another county handle it because of this situation right here. So this whole situation right here could make or break this case on an appeal. And right there, if it looks shady, and be it not everything that looks shady is, but to an appeals court, yeah, this office should not have taken this case. This office, and the fact that all of these people were at the press conference that the county attorney did after he was arrested, that's another part of this whole fucking circus. I don't think that anybody should have been at that press conference except for the county attorney and the FBI. And maybe the sheriff. So the defense also does a really good job right here at getting this on the record and explaining why, like basically setting the foundation for their motion that they said yesterday. But this is providing context that we didn't have in the motion because they had already had this conversation on the record. And there's kind of like you don't need to mention it twice, which I can appreciate, except for we didn't have these transcripts when we read that. Without a rebuttal, seeing what I'm seeing, I would want this case protected and the prosecutor should recuse himself. Yeah, I can't wait to read a rebuttal. So, and it was in a group chat. So the texts we're in a group chat. So we don't know who all in the family. It was a family group chat. So, and the state responds on pages 10 and 11. There we go. So as a lot of this stuff is not important to me. Part of this transcript that was super important to me was the stuff about the motion we read yesterday. We're Karen Reed. We know where group chats get people. Yeah. That's because and there's also a difference, and we talk about this all the time, between what we think we know or what we know and what you can prove beyond a reasonable doubt in a court of law. Yeah, everybody thinks this guy is so guilty that he can't be found not guilty. I'm just telling you, remember Simpson. It's strange that the one just doesn't take themselves out of the case. Must be on top of the one of the top prosecutors. He is a supervisor. According to that motion yesterday, he's in a supervisory role, whatever that means. I can't say I know the structure of a prosecutor's office, let alone a Utah prosecutor's office. I have never been in a prosecutor's office. So, so they go on to say, the court goes on to say, so the one concern I have is I appreciate counsel laying this out. The issue is of the media and photographs and video, because this is very ripe and we have a hearing on the 30th. And I'm just trying to get an idea of where and how much time do we need, because as this court's trying to, it's intertwined. And as I'm looking to what decisions to make, that it's important consideration because it touches upon the issues that we'll be talking about today. And where are the parties with that? The defense wants the media out. Remember what happened to those attorneys on the Simpson case because of what they did? It ruined their careers. Yeah, that's I keep telling, well, I don't keep telling FlashFan. Somebody keeps telling FlashFan that he should stream the Simpson trial, and I told him that would be a year's worth of content and a good discussion. Just saying. Just saying. All right, so the other thing that was interesting in this was on page 15. Whee! So, all right. This is Mr. I think this is Novak talking. Yep. So, or Nestor. Kathy Nestor on behalf of Mr. Robinson, may it please the court and counsel, Your Honor, motion to strike. Obviously, it's more of a procedural complaint than we have on the substance that Mr. Novak is going to cover with you about the shackling. But we have concerns in the manner in which the state replied. And I do think there was a little bit of confusion. And I think we were all trying really hard, admirably, to get the court quickly on this issue because we all recognized this matter needed to be resolved before any additional hearings were held. And I am reading this by myself. So, yeah, he did every Thursday. Every Thursday. It took him 2 years to get through that, I think. I do think there was a confusion. The first order that came out by the court came out on October 13th. In that order, in our motion, we made it clear. Mr. Novak will get into all the details. I don't want to steal his thunder, but we welcome the participation of the sheriff in this process. We recognize that the sheriff would have important information that the court would need to take into consideration in making findings on our motion, our anti-shackling motion, if I'll call it that. So we have invited that. We expect that. We ask that the court consider whatever documents the sheriff needed to participate with, that they would be looked at on an ex parte basis. We certainly recognize that it might not be judicious for us to see the inner workings of all of the jail. We frankly don't want to know any of that. So we had already laid the groundwork in our motion for the information to come from the sheriff. We welcomed it, wanted it, and think it's appropriate. We're a little bit surprised when we got the response that it appeared to us on its face, and I'm paraphrasing a little bit, that the sheriff is entering an appearance as a party with this pleading. And they're actually, through Mr. Van Noy, are lodging objections to our motion as a party would. This is where I'm like, the what? What? Huh? Like, motion to strike the sheriff as a party. And I don't know why the sheriff would need to be a party, but sometimes you just look at stuff and you're just like, why does this even happen? And this is what makes the damn justice system so effing confusing. Because you're like, why would they lodge objections to the motions, for one? And, is that like Randy being called a party by BBB and getting the judge mad when he responded? It could be. I don't know. And this is just a transcript. So we don't have like tones of voices, body language, anything to go with it. And that's the hard part about a transcript, is you don't have the other pieces to the puzzle. And appear through counsel to be heard. That we certainly were not inviting that in our motion that we filed, and we felt very strongly compelled to shut that down quickly and permanently. We did cite to the court in our motion, certainly we recognize the state can and should respond, and that it would be perfectly appropriate for the state to reveal, either through exhibits or testimony at the hearing, what concerns of the sheriffs were. I don't know what to think of this. This is like, seems like a step that didn't need to happen, but did. Yeah. And then the defense goes on to say, we've cited to the court a couple of cases, the Lane and also the Brown case, where our courts, the Supreme Court, have dealt with the issues of the fact that there are only two parties in a criminal case. This transcript is like being deaf and blind, and kind of. I mean, it helps with what was said, but it's only part of the puzzle. It's not like watching the actual hearing, but if you can't be in the hearing or see the hearing, it's the next best thing. It's just one of those situations where it was like, huh? And then you got this. The main thing that stood out to me of all this was the stuff about the motion from yesterday. And sorry, I'm about to sneeze. I felt it coming on for like a minute, and I was like trying to fight it, and I just couldn't. I couldn't come up with words anymore. So there's just a bunch of stuff, and we're not going to read through this. We've been at this an hour and a half. If you guys want me to read the whole entire thing, we can. But the main purpose of this, in my opinion, was the fact that they knew back in October that they were going to file the motion to disqualify, which to me, that little extra tidbit of information about law enforcement being deployed for that particular family member specifically is you got to go. Like, yeah, the transcript is being a volcano, no emotion. We were going all night, chat. This girl's got to work. So if he wants Squid to read the whole thing, she needs $50 in super chats. If I'm going to read the whole thing, I need people to read it with me, because trying to read all these parts by myself, I don't have that many personalities. So now I know you're not a fan of body language. It's not foolproof. I get that. However, there are specific, like, universal proven things. Like, it's like you can tell when someone's angry. You can tell when someone wants to say something but is holding back. You can tell when someone's not confident in what they're saying. So I understand, like, I don't really believe in body language for, like, oh, you're lying or you're not lying kind of thing. But, like, there are you can tell when someone's saying something and they're happy about what they're talking about. You can tell if someone's pissed. That's the kind of body language that I'm referring to when you talk about a court case. Like, if someone's sitting there, like, like this, they don't want to be heard, or they're putting their head down. It's like that kid in class, like, don't call on me, don't call on me. You're trying to make yourself small so you're not seen. You kind of put certain things together. So people are good at reading stuff. Well, I did invite someone to come on stream with me, but they're busy and they don't check their Discord very often, so I'm pretty sure they didn't even see my invitation. So there's that. Hey, Cynthia, how are you? I don't think so. No, my dad is, but I'm not. You're hilarious. There's just certain things, and it is 97 pages, so I have not read. Like I said, I did a word search for things, and I kind of read pages after I found certain words. I read that page. So it's 97 pages. I got it this morning. I did not have the time to read all 97 pages. So remember, this was a closed hearing, so this hearing was probably 2 hours. So, but the one thing that I do know that I have seen when reading what the court says is the judge is very, like, and so what would be the what would be your thoughts if we follow the path and they file the same exact motion? He's very thorough. He asks questions. He repeats back what he hears the lawyers say. So he ensures he heard it correctly. I did not. But like you can tell that he's taking his time. Sometimes almost to a fault, because you know when you take a little too much time to like do something that you start questioning yourself. No, but it's a piece to the puzzle. It's a part of the situation. But I think this is where we're an hour and 40 minutes into this. I think this is where we're gonna kind of cut this one off. If I do, I might, when I'm at work tonight, put this in Speechify and have it read it to me. And if something does come up interesting, I will make a short or I'll put it in Discord. I might screenshot specific pages and put them in Discord because this whole file will not fit in Discord. It is too damn big. And I'm not paying for the premium Discord. I don't use it enough to put massive files in Discord. But the fact that they thought the sheriff was trying to make himself a party in this case, and the sheriff is like, no. But the sheriff is like, I'm totally not a party. So I'm confused on why they think the sheriff was trying to make himself a party. It just didn't make any sense to me. All right. I learned that interviews of a suspect, when they're looking at you in their eyes, they're looking to the right, they're lying. It's all about baseline. If someone always makes eye contact with you when they're answering their name, their street address, like things that are, what color is my shirt? Blue. Things that are obvious. And then all of a sudden you ask them a question and they start doing this. It's not a definite that they're lying, but it's like something changed. And it's like it's not one thing, but if like this changes and this changes and this changes and this changes, maybe, who ordered this cold weather? I don't know, but they can have it back up north. Like I was pretty good with yesterday, and then all of a sudden about 5 o'clock it started to get really cold. And then it was like 33 this morning, and I'm like, I don't know, no. Probably. Probably. I don't like it, yeah, I don't know. Body reading is such an inaccurate science, it's never used in any respectable court. It's not. It's used kind of in, like, if you've ever seen that, they made a TV show about it, Bull. It's kind of used in, like, jury selection and kind of knowing who the jury is, but it's not an accurate science. It's an art form, more of a situation. But there are, like, 5 universal, like, emotions: anger, happiness. So you can use that and you can be like, oh, you look kind of pissed. Maybe I'm not going to approach you today, kind of a situation. So, my head is hurting. But my head always hurts. Welcome to being me. So, all right. Thanks, guys, for joining me for that incredibly simple and quick-ish breakdown of a large document. My main focus was connecting it back to yesterday's stream, because that to me was like, it was like a bombshell being dropped right in the middle of a hearing 2 months before a motion was filed. And it's kind of like, yeah, the shifty actions make you wonder. But I believe I really need to see what the state has to say. Because based on what I'm reading from the defense, this is an amazing defense team. They are on top of their shit. They are doing things early. They are laying the foundation for appellate issues. Like, I mean, there's a reason that they make they make the kind of money they do. I mean, one of these attorneys was one of the attorneys for the Menendez brothers. That one didn't work out so well for him, but very high. He's used to high profile cases. So once the motion that the state files in rebuttal to that is up, I will read it to you guys and we will discuss that. I kind of can't wait for that. I really want to hear what they have to say because there's always two sides to a story. However, if the information about the law enforcement being deployed specifically to find that family member, that is that conflict of interest, and it's the appearance. And y'all might not like Tyler Robinson, but if it's Tyler Robinson today, tomorrow it could be you. And that's never a fun time because we don't have to like somebody to protect their rights. We don't have to think they're a good person to ensure that they get a fair trial. Because remember, if one person gets an unfair trial, it's so easy for it to be us. And I know I repeat that, but it's so damn important. And it's one of the hallmarks of living in this country is that we get a fair trial and we have the right to appeal and recuse judges and disqualify attorneys. And it's our rights. Yes. So y'all have a great day. I will see you tomorrow. We are going to be talking all things. It is New Year's Eve tomorrow. So it will be a quicker stream, but we are going to talk all things TikTok teen, Sarah Grace Patrick, because her trial starts on the 6th of January. And there's some quick motions in limine. There's a bunch of, we haven't talked about any documents in that case in a while. It is Georgia, so I can't download them, but we can go to the site and look at all of them. On that note, I want to see if there's any place I can send y'all. And thank you to the 35 people who hit the like button. I appreciate y'all. Let's see. And the one person who decided to subscribe. And if you haven't, please hit that like button. Please hit that share. I think this is an important topic to talk about for all of us. Whether you were a Charlie Kirk fan or you hated Charlie Kirk is not necessarily the point. The point of this stream and these streams is about protecting our rights. So Flux is live. We will go over and see Flux. Project Zomboid. Y'all go tell Flux that I said hi and tell her to have a happy new year. Bye, guys.